All right, everyone, welcome to another edition. Let's get this thing popping and locking. First round of question is, the EAJA fee issue is causing someone to turn them down. In other words, why is it that when someone wants to get in a case appealed to the federal court level, that if they owe a federal debt, let me back it up, it says, here's our first question. The EAJA fee is caused when someone asks an attorney to represent them in federal court to sue the SSA. When it gets to the level, attorneys will turn them down if they owe the government. Why is that? In other words, this person wants to know, I want to make sure I get my bearings right here. What they want to know is this. I got a case. I've been denied by the judge. I've been denied by the appeals council. My next step is to sue the commissioner in federal court. I want to hire an attorney, but if I got a federal debt, they won't take the case. And I'm just frustrated because I don't understand why, because of this EAJA thing. Could you make some sense of this? Okay, let me see if I can break this down accordingly. EAJA stands for Equal Access to Justice Act. It is the provision within the federal government that allows for a person who successfully defeats the Social Security Administration in the United States District Court or any federal court, whether it be USDC, Supreme Court, or the Circuit Court of Appeals. It allows them the opportunity to get what we call prevailing fees. Let me kind of back this up so that you get an understanding. A lot of federal statutes and even state statutes have what we call a prevailing party designation, or prevailing fee statute to some effect. In other words, what it does is it basically says if you lose, employer, because of the plaintiff successfully winning. In most cases, plaintiffs. You may see plaintiffs, defendants, usually it's plaintiffs. You, Mr. Employer, owes the plaintiff's attorneys money for handling the case. So what ends up happening is that the person gets a lump sum of money because they got all these damages, and then the attorney gets their attorney fees and costs. A little different in this situation. In this one, if you sue the commissioner and you win, it used to be, and let me tell you what I mean by used to be. It used to be that if the attorney was successful in helping you win your case, then the attorney could apply for fees under the Equal Access to Justice Act. In other words, the commissioner of Social Security had to pay that attorney for successfully winning that case for the plaintiff. The case would get sent back down to the administrative law judge level, and everybody keeps on going. A recent Supreme Court decision, I believe it's Ratliff, that was maybe 2009, I think, 2009, 2010, if I don't miss my guess. Under that decision, what they basically said was, in theory, not even in theory, in actuality, the statute indicates that the prevailing party is the plaintiff. In other words, this whole notion that in the past where the attorney could get paid their attorney fees, because this is separate from taking money out of your back pay. This is for an hourly rate that pays the attorney for representing you in your case. That provision is not necessarily correct. The monies for the work should be done technically goes to the prevailing party, which is the plaintiff. So in other words, what normally happens is, let's say I represent you, I did 10 hours worth of work for, $150, $175, $200 an hour, something weird like that. And so all of a sudden I'm like, okay, that should be $2,000 coming to me. No. What the government basically says is that that $2,000 should go to the plaintiff because they're the ones who are the prevailing cost. Now, there's a way you can get around that, meaning if the plaintiff agrees to assign their rights to that money, then the attorney gets paid. Still with me? I know it's kind of confusing. Here's where it gets a little tricky. Because they're saying that the money for the work that's being done really goes to the plaintiff first, any federal debts have to be satisfied before releasing that money to anybody, whether it be to the plaintiff or to the attorney. So in other words, the reason why you're having a hard time It may be a little easier if you've had the representative for the duration of their case. Maybe they say, you know what, I'll appeal it. If they take it, that's fine because I believe in this case, and if it gets back, I can always, get 25% of the back pay because it's going to be a long period of time. That's what some reps do if they've been in the case for a while. But I can tell you as a representative who's been doing this for 12 years, and I can tell you I have had a lot of people who've come to me because whether they had somebody who would not appeal it to the federal court, or maybe they couldn't because they were not an attorney rep and not an attorney admitted to the court, or maybe an attorney who just wasn't admitted to that court. I've had people come to me and say, will you take it in the federal court? Yeah, I have to ask because here's the problem, and I want you to pause for a second. Let's say you successfully win at the federal court level, but then you go all the way back and you owe a federal obligation, whether it be child support, whether it be alimony, whether it be a student loan, whether it be taxes that you owe. So guess what happens? That hourly rate that I was telling you about, $200 an hour, maybe 10 hours worth of work, $2,000, that means I am basically, as a representative, paying your debt. So I'm not getting compensated for the work I'm doing. What's happening is, even when you assign that right to me as the representative, that money is technically your money. So before I see a dime of it, they're going to take it. So just kind of think about how that sounds for a second. I know this sounds rough, so please forgive me when I say this, but I need you to understand that attorneys are business people, and you have to think about it the way they look at it. They've taken your case, they're rolling the dice, and basically what's happening is instead of getting compensation for the work they did, the compensation is going to pay your debt. So in other words, they are working to pay your debt. Now you say, well, I can always get that money back and for the back pay. I say, but you're missing the difference. The standard in federal court is different, and the mechanism for paying you in federal court is different. So when a representative is sitting here saying, I don't want to sit here and take your case knowing that I'm going to do all this work, basically it's one thing to roll the dice in federal court. Maybe let's say we try to get you to file a new application, represent you on that one, because that's usually what some reps do, like myself. We'll say, okay, we'll take your federal one, let's get you a new one going, let's see if we can get to it, both of these things going. But let's say, for instance, that you just have this one case. You can't file a new one for whatever reason. Well, one, there's no guarantee it's going to get sent back down. So they're already rolling the dice once. Two, think about it. Most of these courts, some federal courts could be a year to 2 to 3 years. And it can be really a hyper complicated situation. Like I've had a few of that. And I know that sounds wild, but I need you to understand that these are business people. If they are in a situation, think about it. You wouldn't want to work and basically have your money go to pay somebody else. Imagine you working an 8-hour day, 40 hours a week, and they tell you that your check is going to pay somebody else's debt. So now you're sitting here going, well, wait a minute. You got 40 hours worth of work out of me, but I get nothing because it's got to pay that person's debt. And there's no guarantee that even if it gets brought back, that you're going to win. So that's why it's tough. And this is why I know it's really, really hard. And sometimes what I tell people is that if you got a federal debt, see if you can try to work it out. Meaning contact the IRS if you owe them money. Contact child support and or alimony. Work those things out because, like I said, representatives are business people. They don't want to give money away. And if the representative feels that that's what they're doing, they're basically doing work just to pay your debt, they're probably not going to take your case, especially if they're just getting into it late.